philosophy that both parents do have an equal duty to support their children. Title 4D is the Child Support Enforcement and Collection Program put together by the federal government. So it's a federal program that's state supervised and county implemented. You're familiar with those kinds of programs. The Title 4D welfare program causes some problems or causes some myths. It's based on some presumptions that carry through the whole implementation of 4D, which causes concerns for us, and I'll go through a few of them here. The Title 4D system is premised on the assumption that moms have custody, and I'll go through later why that is. The 4D system is based on the belief that women are unable to self-sustain. The 4D system is based on the myth that dads don't want a parent and are only minimally involved with their children. And the 4D system is contingent on the fact that one parent is labeled an absent parent. The 4D system is based on the erroneous belief that dads won't support their children unless they're forced to pay. In fact, in the early 1970s, when they were looking at the 4D program for the first time, the National Organization of Women testified before Congress regarding why these child support laws were needed. And they testified saying that because they were getting, just by default, having custody of all these children, they made it clear to Congress that their views at that time were custody of the children to the mother is not an award, it's a sentence. That's why they created the 4D program at the federal government, to try to rescue these women from the burden of custody. The other premises or myths or basis of the 4D system include those that are on here. What it does and the problems it creates is it builds a huge bureaucracy that supports one parent at the expense of the other. It gives the custodial parent a sense of invulnerability because they have this whole bureaucracy on their side. It creates increased animosity between parents, pitting one against the other, driving a further wedge because you've got that whole system that's constantly initiating actions that the custodial parent hasn't even initiated themselves. This creates a deeper conflict, and conflict is what's worse on kids. Conflict is worse on kids than divorce itself. And the 4D system then is based on the concept that the custodial parent will get everything because remember, and you'll learn as we go through the presentation, that the assumption is the dad's not around. The 4D system, because it provides all these things for the custodial mom, provides everything for the custodial mom, and I say mom or dad, if I say those words erroneously through my presentation, there are non-custodial moms and there are custodial dads, but sometimes I slip up and use gender-based language, mom and dad, and that's only because, according to the University of Minnesota, 90% of the divorces and paternity cases in Minnesota result in custodial mom. So forgive me if I use those a little too loosely at times. The 4D system, probably the worst thing, and why there's so much of an uproar on this, is the sense of fairness is absent in the 4D system because the power of equities are not used in administrative law. And all these proceedings are done in administrative hearing process. The next section is public rights versus private rights. I just want to review that by saying that there's two different kinds of law. There's public rights and private rights. Public rights where there's a government interest, and private rights where there's no government interest. If one company, one small mom and pop shop is suing another because somebody slipped on their sidewalk or whatever, it's going to be all handled in private law. The government's not going to be involved in that. And there's also, with regard to the difference between public rights and private rights, I'm sure I don't need to review this for you because you're legislators and you're here and you know all this, but in private rights, everybody's protected by the Constitution. And in public rights, everything is statute driven. And in public rights, when the government is involved, there's always a compelling state interest. There's always a protectable interest by the government, a pecuniary interest, a safety interest, an interest for the general welfare. But the general welfare has limitations according to the law. And on the far right-hand side there, private domestic relations has been left up to the states. The federal government, according to the Constitution, does not get involved. And here is a report from the Congressional Research Service out of Washington that says, under the U.S. Constitution, Congress has little direct authority to legislate in domestic relations and family law issues. That's the private matters. And that's clear the way our Minnesota statutes are written. In chapters 245 through 267, it's all about public welfare when the government is involved. In chapters 517 through 519, the revisor's office has labeled those chapters in the statute as private domestic relations. As Title IV, which is the rubric for that, is needy families and child welfare. I can tell you exactly what that says, but that's the focus for Title IV. So Title IV-D is a segment of Title IV of the Social Security Act. Title IV-D is child support collections and enforcement, to give you kind of a picture of how this all fits in. So what are the limitations of the Title IV-D Welfare Service Program? Well, as our researchers went back and studied this, not only back to 1935, but we've been back to 1912 to try to understand the whole evolution of these programs. Title IV was created by the federal government, and it was for a limited class of people, for needy and dependent people, to ensure their basic needs. And then we've got lots of references on how the whole Title IV is limited to those in need and those who are dependent on the government. Sometimes that word dependent gets confused when we talk about dependent children, because people think of dependent children as anybody 18 and under. But that's not true for Title IV of the Social Security Act. We're talking about dependent children, dependent who have no parents to provide for them, no relative to provide for them. So here you can see the legislative history here where it's limited to need and dependence. Here's another reference from legislative history of the Social Security Act, talking again about needy, dependent children. That was the appropriation for Title IV. So then we need to look at two different words, needy and dependent. What are those? According to a private independent report going back to 1946, as they were studying the Social Security Act, they made it clear in that report, and many others I might add, that need was defined by a strict definition. That definition in Minnesota law was clear in 1937, that a dependent child not only was under the age of 18, but was deprived of parental support because of continued absence from the phone from the primary wage earner, and not or not just, or not eliminating, but and whose relatives, nobody's relatives, no one is able to provide for them without public assistance. Years have gone by. What amendments have occurred? Well, our research team has studied. If you were to take the paperwork of all the amendments of the Social Security Act, it would reach from here to the moon. So yes, there has been amendments. We've studied the specific Title IV-D amendments going all the way back to 1974. I've tried to summarize some of them here for you today. In 1984, there were many changes in the Child Support Amendment. And one of the things that is causing confusion with what these amendments is this kind of statement here in red, that this amendment changed things. The federal government tried to change things so that the demand for equal services, so that the demand for equal services for welfare and non-welfare could be fulfilled. Okay, but what the Minnesota DHS is coming back and saying is, well, in 1984, the federal government made us provide these services to everybody, welfare and non-welfare. They changed the laws in 1984, is what the Minnesota DHS is claiming in individual sessions with you and others. Well, our research team has done the research. We've looked through the entire legislative history with all of the federal documents to figure out what was intended and what was meant. Well, it's clear on the record that the record is filled with these kinds of comments here, as from Senator Dole, that the purpose of this 1984 amendment was to place new strong emphasis on the non-welfare caseload, because when child support payments are missed or never received, that can make the difference between remaining independent of welfare or being forced back onto public assistance. So you see how he was really referring to the at-risk group. And if you pour through the legislative history, you'll find these kinds of comments over and over and over again. There's nothing in the 1984 amendments that show that they expanded the class to include every child in the universe. Another one of our own favorite Minnesota senators, Dave Durnberger, is also on the record, and he has a similar comment. In his statements, he talks about the same thing, how women who are divorced or have had out-of-wedlock children, they cannot find work. And especially those that have been married for a while and been stay-at-home moms, that, they'll be forced to public assistance if we don't help them continue to get these support payments. They'll fall on welfare again, and we don't want them to fall on welfare again. We want to decrease that dependency. I've spoke with Senator Dave Durnberger, and he supports our research and our interpretation of what has happened all along the way. So hopefully that will give you an idea of what really happened in 1984 without getting into too many details. There's lots more details I could talk about. So then we continue with the amendments. In 1996 is when Clinton came out with the Welfare Reform Act, also known as the Personal Responsibility and Work Opportunity Reconciliation Act. They mean the same thing. If you see them, they're interchangeable. In 1996, people that I've talked to have said, as I've talked about the evolution of the 4D program, they've said, well, Clinton changed everything in 1996. Didn't you know that? Well, we've done the research. Our research team went through, again, the legislative record to see, did anything happen in 1996 that made the 4D program required to be applied to everybody in the universe? Well, in testimony in April of 2003 in front of the House Human Services Policy Committee, a representative from the DHS, who's no longer there, said Congress made it abundantly clear in 1996 Welfare Reform Act that 4D services had to be provided for any individual who applies for application. That was the DHS testimony in a hearing in this room, maybe even. However, we've done the research and we're not able to find it, and they have not been able to provide exactly what that is. We have found instead that in 1996, Clinton's whole purpose was time-limited assistance and increasing individual responsibility. One of the things that we found as we've poured through the amendments from 1996 is just more information to support our position. For example, this is a section of the public law that's been changed and modified. What they did is there was so much confusion on what do you mean by dependent child? Do you mean dependent child dependent on the government, or do you mean dependent child under 18? So here in 1996 law, they clarified it, and they, by striking the phrase who is dependent child and adding with respect to whom assistance is being provided. So under 4A, which as I said is the MFIP, TANF, and those such programs. So we can't find it where anything changed in 1996. And believe me, we've dug and dug to try to get the research. So how has this philosophy impacted the unauthorized, what we call the unauthorized expansion of the 4D program? The biggest question is who falls in the at-risk group of 4D recipients? We talked about so far that it means those that would fall on public assistance if they didn't get their child support. And we've also said that the DHS thinks everybody must fall into that class. But I hope that we can agree on this, that Kathleen Blatz, as a divorced person, did not become at risk of falling on public assistance just because she got divorced. I hope we can agree that Susan Gertner, just because she got divorced, didn't mean that she was going to fall on public assistance. Same thing with Pat Anderson, our state auditor. Does she need Title 40 welfare services? I hope that we can agree none of those do. Also, add some more. Elisa Rockefeller Dayton, when they were divorced, did she need 4D welfare services did she need the government to come in and make sure that child support was received from Senator Mark Dayton? What about Michael Jackson? You know what? He's a custodial dad. He can go to the California DHS office, fill out an application for $25, and have the government go after his, ex-housekeeper who's now a maid in a hotel to get child support for him. According to the Minnesota DHS, that would be a requirement of the DHS. So we're trying to get to that at-risk group and who should be on this program. Now, the Minnesota DHS will tell you all these people. They have to provide services to all these people if they filled out an application. Well, no one's stopping anybody from filling out an application. And the DHS is saying, when you say, why are you doing this? Why do you provide these services to everybody? They say, the feds make us do it. Well, you know what? Absurdities in law must be questioned. And I think we've learned that lesson from Rosa Parks. I was listening to some of the coverage on Rosa Parks, of course, over the last few weeks upon her death, and there was some recordings from her when she was booked and charged. She looked at the police officer and said, "Why are you doing this?" And he looked at her and said, "I don't know, but that's the law." It's that same sort of absurdity and that same sort of challenge that we need to have, and those eyes that we need to have as we look at the Title IV-D program. The United States case law is clear too, that the role of the judiciary in cases of this sort, going back to 67 when all this was going on, begins and ends with assuring that the commissioner's regulations fall within his authority to implement the congressional mandate in some reasonable manner. Well, the Supreme Court is making that decision. That also is true for legislators as well, because if the agency is carrying out a program beyond its reasonable manner, beyond congressional intent, it's time to challenge that. For example, in Hennepin County in 2002, they had to do a $5 million tax levy just to pay for this program. And I could give you details on other counties. We can search through your county for you if you want to know the information. Let me know. Then we found some more information. There's a brief written by Ken Starr when he was the U.S. Solicitor General, and there he was talking specifically about the 4D program. The 4D program was designed by Congress to save federal and state funds, what I told you before, by recovering assigned support payments from absent parents of children and families receiving AFDC benefits, and to reduce the number of welfare recipients, consistent with what I've told you. Ken Starr says this plan would be undermined if Title IV-D became an entitlement program, which guaranteed specific child support and services to all individual AFDC recipients. So here he's saying that the services are not even guaranteed for AFDC. Why would they be guaranteed for non-AFDC? You've got to ask yourself that question. Then it was interesting, there was also some testimony on file to Ms. Fry, who at that time was the chief of the Office of Child Support in California, testified in front of the U.S. House Ways and Means Committee in Washington in 1997, and she was incredibly frustrated because they were coming out and revising all of these incentive programs for Title IV-D. And she's like, wait a minute. You know, the proposals here for these incentives are crazy because it's encouraging states to recruit middle-class families never dependent on public assistance and never likely to be so, recruiting them in their programs to maximize federal incentives. And she went on to say that her colleagues across the country have been talking and informing her that the way to win at this system, meaning the 4D incentive system, is to recruit the middle class so that you can bring in the higher orders into the system and get more money in your state. So when people say it's all about the money, it's not so much all about the money between the mom and the dad. With regard to the 4D system, it's all about the money for the agency. The U.S. House Ways and Means Committee, in their book, acknowledged Ms. Fry's testimony, and in their Green Book, if you're familiar with the Green Book, it comes out about once every 2 to 3 years where they analyze all of the programs. They made it very clear in there that they know the 4D program may be recruiting more and more cases from the private sector.
See that scale? That's not balance. God damn it, you're guilty before you even go in. You see what I'm saying? Guilty before you even go. Ain't this crazy? Or they done did what? Came up with the man in the house rule. This was a Ponzi scheme. The man in the house rule, kick him out and then charge him child support. That gimmick been going on for how long? How many centuries?
Programs, they made it very clear in there that they know the 4D program may be recruiting more and more cases from the private sector, bringing them into the public sector, providing them with subsidized services, but not greatly improving overall collections. So they know this is happening. They know it's a problem. And yes, we have contacted many people in Washington about this issue as well, and will continue to do so. Well, first of all, you might ask yourself, how are private cases being recruited into the 4D program? How does this happen? Well, one of the first things that happens is when a private party gets divorced and they're in court, oftentimes the judge will order wage withholding in a divorce situation. In and of itself, wage withholding, income withholding is not necessarily a bad thing. But they're doing this based on some real misinterpretations. First of all, many judges will tell you that they believe wage withholding is required by federal law in every divorce and paternity case. We've looked at the record, we've done the research. That's not true. The truth is the federal law can only require wage withholding in 4D cases. Remember what I said before, that they have no jurisdiction over private domestic relations. And federal law allows good cause exemption even in 4D cases. Secondly, many judges believe that wage withholding must be done and can only be done through the 4D system. Well, the truth is that there are three kinds of wage withholding or income withholding. You can either do full 4D services if you want to go sign up down at the county to have them take the money out of your paycheck. Two, there's something called non-4D wage withholding only, which most people don't even know exists, where a divorced couple can get the wage withholding service, but they're not in the whole 4D program. There's also private direct deposit now. The 4D agency, the state DHS, is started to, rather than require the non-custodial dad to write their check to the state and then they resubmit a check to the custodial parent, rather than doing that, the state is working with the new banking technology and trying to use direct deposit, which is fine and good, but what that also means is two individuals who are divorcing can set up their own direct deposit independent of the government. They don't need the government to do that for them. So what happens? Somebody gets an order for wage withholding, so they go down to the county and they fill out a 4D application. First of all, the 4D agency doesn't tell them there's two kinds of wage withholding. They just shove in front of them a 13 or 16-page application, which I have here today if you want to look at it. And they say, this is what you need to fill out the services. So unbeknownst to the custodial parent filling out the application, they suddenly sign themselves into this big program they don't even know that much about. Now, the state law and the federal law do require full notice and full disclosure of everything it means to be in that program, but we can only imagine what is actually said during that application transaction, or not said. One interesting thing, too, at the very end of the 4D application here in Minnesota, there's a signature clause. In that signature clause, which the applicant parent signs, one of the key things in there, and it says, I understand that the county attorney's office represents only the county and the state. The county attorney, the 4D agency, does not represent either parent, and the 4D agency does not represent the child. There's so many people, even in the 4D system, that will say, well, we're there for the children. They're not there for the children. The county attorney and the 4D agency are there to protect the government interests. If you go back to what I said before, that the 4D system is provided for those on welfare and those at risk of falling on welfare, the 4D agency there is there to protect those two interests. The money part of it. They're not there to protect anything but that. Responsibility of the 4D program, and hope that we can work together with you to figure out fiscally responsible decisions that can be made to put this program back into compliance. And with that, I'm ending about 10 minutes early, so we have plenty of time for questions.